morning, everyone. I am Genevieve Ejoy from BTL2E. And for today's video, I am the first reporter and I will be discussing all about the IPRA Law and the 3Cases. So first, we have the introduction. So here in the introduction, we have the short overview and we will going to define what is IPRA Law all about. And now let me read first the IPRA Law. IPRA is a comprehensive legal framework anchoring the rights of indigenous people and land, governance, culture, and development. And also, IPRA is also known as, or officially known as, the Indigenous Peoples' Right Act of 1997 or Republic Act number 8371. It is a landmark Philippine law that seeks to recognize, promote, and protect the rights of indigenous cultural communities and indigenous peoples or IPs people. Speaking of indigenous people in the Philippines, we have major groups include the Highland Igorot, Bogkalot, and Mindanao's Lumad, as well as various Eta and Mangyan communities. And did you know that indigenous people global overview are approximately 476 million indigenous peoples across more than 90 countries, representing about 6% of the global population, yet they account for about 19% of those in extreme poverty. And also, indigenous people can speak over 4,000 of the world's languages, many critically endangered. So now let's move on to the second slide. What IPRA protects? So we have 6 IPRA protects. So what are those? So first we have the ancestral domains land rights. Second, self-governance empowerment, cultural integrity, social justice, human rights, free prior and informed consent or the FPIC. And the last but not the least is the natural resources and environmental rights. So now we're going to discuss one by one of what IPRA protects. So first is the ancestral domains land rights. So which is legally recognizes ancestral domains that commonly held lands, waters, natural resources, and culturally significant areas traditional occupied by IPs, and it is also grants ownership, possession, and development rights even sites like hunting grounds, spring water sources, burial grounds, and sacred areas. Next is the self-governance empowerment. So self-governance empowerment affirms IP's right to self-determination and self-governance, respect for their customs and establishment of their own justice systems and conflict mechanisms. And it also includes mandatory participation in national or local decision making and respect for indigenous political institutions. Third one is the cultural integrity. So cultural integrity is safeguards indigenous traditions, languages, rituals, sacred sites, and intellectual property to prevent unauthorized use or commercialization. It is also grants communities ownership over cultural expressions. Next is the social justice and human rights. So when we say human rights in Tagalog, karapatang pantao. It is the right to protect IP's people from discrimination and guarantees culturally sensitive access to education, healthcare, employment, and public services, and also ensures equal protection under the Constitution and universal human rights law. So that what we call social justice and human rights. And the fifth one is the free prior and informed consent or the FPIC. So what is the purpose or what is the aim of this right? So free prior and informed consent or the FPIC is to protect the rights of indigenous cultural communities, indigenous peoples over their ancestral domains and cultural integrity. And FPIC empowers IPs to decide freely and independently whether to accept or reject, projects mining mining, logging, or dams that affect their land's resources and lives. And the last but not the least is the natural resources and environmental rights. So it is gives priority to IPs in managing and harvesting natural resources within their domains. It also requires benefit sharing agreements for any external resource use and protect against environmental harm. Before we're going to proceed to the map of the area of indigenous people here in the Philippines, I would like to share the IPRA core rights and effect and case law, which is integrate IPRA rights from the 36 rights bundle. And the question is how courts apply them. So courts apply them by ancestral domain ownership, self-governance, and customary law. And the last but not the least is the free prior informed consent, or the FPIC implications. That's the map of the indigenous people here in the Philippines. So as you can see, there's a different colors that represents indigenous people. So first color we have the color brown, which is the Negrito of Luzon, and the green is the Igorot, and the dark blue is the Mangyan, and the sky blue is the tribes of Palawan, and the khaki color Ati, and the purple or violet is the tribes of Panay, and the red one is the Lumad, and the last but not the least is the yellow Bajau. So that's the map of the indigenous people here in the Philippines. Historical groundwork. So here's a refined look at the historical groundwork leading up to the Inter-Pacific Indigenous Peoples' Right Act, or IPRA Republic Act 8371 of 1997. As you can see in our PPT, there's only the summary of historical groundwork of IPRA. It's because I will discuss the timeline overview of the history of the IPRA law. So first, I will discuss the pre-colonial Spanish era, which is before colonization. Indigenous communities had established customary laws and local dispute resolution systems long before state institutions existed. For example, native judicial systems with chief, advocates, judges, and rules for divorce, inheritance, and etc. operated in pre-colonial Philippine societies. So in the Spanish colonial rule, through the laws of the Indies, turned communal lands into crown property, destroying indigenous lands' rights and banning customary practices, replacing them with feudal systems. And the American period legal precedents, so in the year of 1909, which is the American period, like what I've said earlier, the U.S. Supreme Court in Carreño v. Insular Government recognized the doctrine of native title, legally acknowledging ancestral land rights. This Carreño doctrine later became foundational to IPRA's ancestral domain provisions. National constitutional foundations. The 1987 Philippine Constitution explicitly recognized indigenous cultural communities and directed state support for their ancestral domains, and the UN Declaration on the Rights of Indigenous Peoples 2007 followed IPRA but added another global layer to the rights discourse. From advocacy to legislation, indigenous groups like the Cordelia or the Cordilla People's Alliance or CPA led national campaigns to assert land rights and self-determinations. NCIP's predecessors and civil society actors undertook community mapping and advocacy to document customary laws and ancestral boundaries, foundational steps for title application. So finally, on October 29, 1997, President Fidel V. Ramos signed Republic Act 8371, establishing IPRA and the NCIP or the National Commission on Indigenous People, setting into law communal land rights self-governance, FPIC or the free, prior, and informed consent, cultural protection, and recognition of customary judicial systems. So, by the way, IPRA or the IPRA law, it was signed by the President Fidel V. Ramos. So, in what year or in what date? So, in the year of 1997 or October 29, 1997. So, the NCIP or the National Commission on Indigenous People is the agency that under the IPRA law. So NCIP is agency. So that's the historical groundwork of the IPRA. So let's proceed to the summary of the historical IPRA. So let me read the summary. IPRA stands upon centuries of indigenous legal traditions, punctuated by colonial suppression legally revived by American-era jurisprudence, aligned with international human rights norms, anchored constitutionally driven by grassroots activism, and finally codified in the year of 1997. So the first case we have is Cruz versus DENR, Secretary of Environmental Natural Resources. So this case we're going to find the main reason, the main issues, and the arguments of this case. And this case is one of the landmark cases that challenge the constitutionality of the IPRA law. So to deeply understand and to find the main issues and the arguments, here's the background. So the background, we have the petitioner and the respondent. So the petitioner we have is former Supreme Court Justice Isagani A. Cruz and attorney Cesar Europa. So if we have the petitioner, of course, we also have the respondent, which is Secretary because the Regalian Doctrine states that all lands of the public domain, waters, minerals, and other natural resources are owned by the state. So that's the reason why Cruz argued that IPRA is unconstitutional, because he claimed that IPRA grants ownership, possession, and development of the ancestral domain occupied by indigenous people, which violates the Regalian Doctrine from the 1987 Philippine Constitution, Article 12, Section 2. So Section 2. So the question that we're going to answer is, does IPRA violate the Regalian Doctrine? So here's the answer. So the answer is, indigenous people have been occupying their land since time of immemorial. So it means no, IPRA does not violate the Regalian Doctrines. And these lands were never public lands in the first place, because IPs owned them before the concept of state ownership even existed. And also, IPRA does not grant ownership, it recognizes existing ownership based on customary law and native title. So therefore, it does not conflict with the Regalian Doctrine. So there is no grant of ownership. So overall, IPRA law is constitutional. It's not unconstitutional. It respects indigenous ownership without violating the state's control over natural resources under the Regalian Doctrine. So the key point of this case is the court emphasized the primacy of customary law and the jurisdiction of the NCIP, National Commission on Indigenous People, over disputes involving IPs and their ancestral domains. So the importance of this case, it reaffirmed the authority of the NCIP in handling such cases before they are brought to regular courts.
So, good evening everyone. My name is Lovelyn Febrea Moay, and I am the second and the third reporter of these three cases.
The second case is the case of the Mananwa tribes, 2014. The Mananwa tribes is one of the Philippine oldest indigenous group, has faced significant challenges in asserting their ancestral lands right and maintaining their cultural heritage amidst external pressures. Their experience highlight broader issues of indigenous lands right, governance, and environmental conservations in the country. Ancestral domains and the legal recognitions. The Mananwa's ancestral domains spans approximately 49,870 hectares across several municipalities in Surigao del Norte, including Claver, Gigakit, Bacoag, Alegria, and Tubod. These areas was officially recognized under Certificate of Ancestral Domains Title CADT number R13 CLA-0906-048, affirming their rights to the land. They have conflict with mining operations. In 2010, tribal leaders Dato Rinanti Boklas and Dato Alicia Patak entered into a memorandum of agreements with Shinzu Mining Group Corporations and the National Commissions of Indigenous Peoples or NCIP to allow mining activities in Barangay Cardianao, Claver. They were misled into believing that Shinzu held unnecessary mining permits. Subsequently, it was relieved that the actual permit holding was Claver Mineral Development Corporations, and the tribe did not receive the agreed upon royalty payment. That's why the NCIP later declared that compliance certificate issued to Shinzu void due to irregularities and the delegation of authorities supporting the Mananwa's claims. That's why in 2013, a faction of the Manubo tribe attempted to claim a portion of the Mananwa's ancestral domain under CADT 048. This led to resolutions by 18 Mananwa's leaders urging government agencies to disgrade the Manubo claims to prevent further conflict. They faced the environmental livelihood challenge. The Mananwa's traditional practices such as kaingin, slash and burn agriculture have contributed to environmental degradations. In response, the Department of Environmental and Natural Resources or DANR interviewed offer to Mananwas to community-based forest management agreement or CBFMA to promote sustainable lands use and provide livelihood support. The Mananwa continue to face challenges in asserting their rights and securing benefits from their ancestral domain. Issues such as irregular royalty payments and authorization mining operation persist, prompting calls from greater accountability and support from governance agency. So that's why that was the ongoing struggles and government response. So that's why we can say that the Mananwa tribe's experience underscore the complexities indigenous communities faced in protecting their ancestral lands and maintaining their cultural identity amidst in external pressures. So the Mananwa tribes was so pressured because of the this operation violation of the IPRA or Indigenous Peoples Rights Act. The Mananwa tribes' rights to their ancestral lands, cultures, and way of life were being violated. So, if there is a violation here, say the case of the Mananwas people, it's usually about much deeper or than just a legal dispute. Like, it's about land disputes, displacements, and destruction of sacred spaces, or being pushed off ancestral lands. These kinds of violations impact families, children, elders, and entire communities. Imagine growing up in a place where your ancestors lived for generations, and then one day, without much warning or consultation, that land is taken from you, often by large corporations, mining companies, or even government projects, leaving you with nowhere to go. So for the Mananwa, as with many indigenous group, their lands isn't just a resource, it's their history, their connections to the earth, their spiritually, and their way of life. Violations of the IPRA aren't just legal breaches, they can lead to the erasure of entire cultures, languages lost, and social upheaval.
The second one is the Tomandok Tribe 2020. The Tomandok tribes are an indigenous group primarily residing in the island of Panay, particularly in the province of Capiz, Iloilo, and Antique, sometimes referred to as the Panay Bukidnon. They are known for preserving rich traditional oral epics and a deep connections to their ancestral lands, especially in the mountainous areas. Their cultural includes the Binonag dance, Suginanon epics, and intricate knowledge of nature and traditional farming. However, the Tomandok faces threats from land encroachment, development projects, and militarization, leading to displacement and rights violation. On December 30, 2020, at approximately 4 a.m., joint operators by the Philippine Army's 12 infantry battalions, the Criminal Investigations and the Detections Group or CIDG, Western Visayas, and the PNP were conducted in Line Village across Tapas, Capiz in Calinog, Iloilo. More than 2 years ago, on December 30, 2020, Philippine Security Force entered the houses of indigenous Tomandok leaders from 6 barangays in the upland areas of Calinog and Tapas on Panay Island, and brutally killed 9 of them in the presence of their families. This joint police and military operations was called Oplan Paglalansag Omega. The dead were identified as Roy Giganto, Reynaldo Katipunan, Garson Katamin, Elisio Gayas, and Maurito Diaz, Artilito Katipunan, Mario Aguirre, Jomar Vidal, and Rolando Diaz. The Tomandok leaders were falsely accused as member of the New People's Army or NPA. The police justified the killings by stating that the victims had resisted search and arrest warrants. However, testimonials of the families refuted this claim. These victims were known leaders of their communities who had peacefully fought against the construction of the Jalawar Mega Dam and for the protections of their ancestral domains and their people. This is the blatant blow in the face of the Tomandok, and everyone's fighting impunity. The possible promotion is chilling encouragement for security forces to commit further human rights violations without having to fear any consequences, but to expect honors instead. In a statement issued a day after the killings, the Police Regional Office Western said the operations was carried out based on information gathered from locals about the presence of people with high-powered firearms. It was intended to curb the proliferations of the firearms in the explosives in Panay Island. In a separate statement, the Legal Corporation Cluster chairperson stated that the police operations are directed at the CPP NPA, who are said to have infiltrated Panay Island's provinces. It was mentioned that the killings and death carried out as part of the police operations had put an end to what he refers to as a CPP reign in PAs of terror in the province. but relatives of the victim said that those who died did not resist arrest and that the firearms and explosive found in their residence were set up.
After hearing all of those cases, what IPRA protects, what IPRA all about, we realize and we all know that indigenous peoples are vital guardians of cultural diversity and the environment. And Philippines IPRA aim to protect their rights, but implementations remains uneven. And supporting indigenous sovereignty and rights is essential for preserving both human heritage and the planet's well-being. And that would be all. Thank you, and I hope you learned something. And once again, I am Genevieve Ejoy and my partner Lovelyn Yimuway. And the case dismissed, and thank you for watching. Bye!